Okay, we're on the record in the matter of the people of the state of Michigan versus Brandon Scott Craybill, file number 23-03160. Can I have your parents' counsel?
Good morning, Judge. Carrie Angie appearing on behalf of the Attorney General's office. My video should be starting any second.
Mr. Craybill, can you unmute your device?
Yes.
Okay. Okay, and then today was the date that I reset this matter for a review because we were still waiting for the check to clear with a friend of court. Counsel, did we get a clearance yet?
Your Honor, my office spoke with the friend of court this morning, and as of yet, the check has not cleared the system.
I do have a little bit of an update there. There's it shows on their processing, but it's like was just said, it hasn't actually cleared, but you can see that it's being done. So it seems like it'll happen soon.
Sounds good. We're gonna reset this to March. Whenever we're available, because this is the longest one processing check ever.
We can do March 15th.
March 15th at 9.
Okay.
Thank you, Your Honor.
Thank you.
No problem. Any additional matters today?
No, Judge, thank you.
Thank you. Have a good one.
Likewise.
Thanks.
On the record in the matter of the people of the state of Michigan versus Joshua Scott Day, file number 24-00368. Counsel, may I have your appearance?
Assistant Prosecutor Paige Petrowski on behalf of the people, and Assistant Public Defender Sarah Donnelly on behalf of Defendant Joshua Day, who is appearing separately by video.
Okay, Mr. Day, you can hear us, correct?
Yes, ma'am.
Okay, today was the date and the time set for probable cause conference. This matter is scheduled for a preliminary examination February 29th 8:30 in the morning. Ms. Donnelly, my understanding is that you wanted to address something on the record.
Yes, Your Honor, yes, we're leaving it on for preliminary exam right now. There isn't an offer, but we're gonna work on a global offer. He just has several files in review and needs swear tos. But in the meantime, he is being held on multiple warrants, including one for an extradition. I have no idea.
I wasn't able to find anything.
We'll try to figure out what's going on, but he wanted to address medical issues. Right now, he says he's in a lot of pain and discomfort. He is getting his medications not as prescribed. He is supposed to be taking them with food, otherwise he gets incredible upset stomach. But you know, the rules of the jail are that you can't outside, you know, you have to eat your food during the meal hours, and if you don't, whatever you don't eat gets taken away, so he can't even save food, so when he gets his meds, he can have them with him. But I think that's what he wanted to address. If there's anything else, Mr. Day, that I forgot.
Like you've covered most of it, the doctor, several different jails.
So Your Honor, I didn't know if there's anything the court could do. I didn't, honestly, I was just a shot in the dark, but I just thought to bring it up.
I'm not
Like I
really
said,
sure
it's
what's going on with, you said he's having stomach issues as it relates to his meals?
Yeah, he has a certain medication. He's required spinal surgery, and because of his disease, he has degenerative disc disease, among other things. He takes medications, but one of his medications, if he doesn't take it with food, he gets more sick. And so, yeah, they say they refuse to give him or allow him to have food with that one medication.
And like I said, the doctors ordered several different
Doesn't seem like
treatments.
an unreasonable accommodation request. The best I can do is reach out to the jail and find out why they wouldn't give him at minimum a cracker or something, banana or something before he takes the medication.
I
It says
appreciate
it needs to be taken with food. So the court will reach out. Obviously, I don't have any control over what time you get a meal over there. And I don't know if your medication is needed to be taken at a certain time. Is that could be the issue? You can't
Yes,
take it
they
at
would bring-
meal time. Is that what's going on? You have to take it as the medication at a certain time?
Well, they only bring the medication to you at certain times, and there's about 4 hours past each meal time.
Oh, okay. So they bring it to you 4 hours after you had breakfast or lunch?
Morning and then after dinner. They bring it, we have breakfast at about 5 a.m. and then they bring the med about 8:30 to 9 a.m. And then in the evening, we have dinner about 4:30, and then we get the medications anywhere between 8:30 p.m. to 10:30 p.m.
Okay. I'll make sure I send some communication over to Ingham County Jail to see if that's accommodation that they can make. I don't see why it would not be one that they can make. That doesn't seem as an unreasonable request. So I'll do that, okay?
In the past, that's what they used to do. They would give you a sandwich or something, to take with your medication. Why they stopped doing it. The doctors also made a couple of other requests, to have special shoes for me that the jail provides, and extra blankets and extra stuff like that the jail has not accommodated me on as well. So I find,
Okay, you've kited for those things already?
have.
Okay, I'll do that, and then your attorney, I'll send an email, I'll CC your attorney in the prosecutor's office, and then your attorney can follow up on that, okay?
I appreciate your help.
No problem. Any additional matters for today's record?
Nothing for the people, nothing for defense. Thank you.
Thank you, you're all set. Ms. Wanchi. How are you?
I'm fine, thank you. And you?
I'm doing well. My understanding, Mr. Day, you're free to go.
Thank you very much. Have a good day, Your Honor.
Same to you. My understanding is that we weren't aware that Mr. Coleman is in the custody of Oakland County. So I found good cause to reset this because we can't get him written in 7 days. So,
Right there?
Yeah.
Yep.
why is this, can you adjust the screen, please? I don't know why it's oh, there it go. It's looking a little better.
Is this for Mr. Austin?
No, no, Mr. Day just left. He was in that room.
Okay,
We need Smith now, but not that Willie Smith.
Stephen Austin is a polycom with Aaron Schroeder, so he's just supposed to log in. He's supposed to log out so that she can log in with him.
Oh, okay. Is that before someone's court or just
No,
a
it's,
private?
yeah,
polycom?
public defender Aaron Schroeder.
Okay, yeah, it looks like he's supposed to meet with his public defender. So you gotta log out, so I guess she can meet with his public defender, he can meet with her.
okay, so Mr. Austin is okay then here?
Yeah,
He's okay in that room, he's not okay in the courtroom because we don't need him here, he's not on my docket. He, I think, had a polycom scheduled for his attorney.
Yes, ma'am.
Is she
Okay.
logging in there? How does that work? Do they log
well,
in?
he'll give a busy signal until they disconnect.
Okay, yep, you're gonna need to disconnect because if she's trying to contact, it will get a busy signal. Hi, who do we have in the jail?
Mr. Smith,
There we go. Okay, and then we have Josh Bud. Okay, Joshua Blazinski. Is what I'm assuming his name is. Did we get a new date for Coleman? I didn't. I think I passed him the file, that's why. Let's see. We'll do a new PCC and PE.
March 7 and 9:30.
PCC March 7 at 9:30.
Exam, March 15th at 10.
March 15th, at what time, 10?
10:30.
10:30 for the exam.
Thank you.
No problem. Is Kemp in custody downstairs or?
Yes.
Okay. And then, Ms. Donnelly, you have David Larson.
Your Honor, David Larson's not here.
Have you had contact with David Larson?
I got a voicemail from him yesterday that he was stranded in the UP, his car broke down. But I haven't read any word about him having a problem with his tether this time. So I'm assuming he still has it in his truck.
I think he is sentencing today.
Yeah. I can't stop laughing.
Well, I'll show a picture warrant. Shows failure to appear. And then, let's see. Mr. Mills is here for Marcos.
He's just outside and we'll grab him.
Now you have warrants.
Lawrence and Mr. Taylor, 2% sentencing.
The record in the matter of the people of the state of Michigan versus Jeremiah Marcos. This is file number 23-02623FY. Appears for the record.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Hey, good morning, Your Honor. Stephen Milton, Marcos, who is present and standing to my right at this time.
Okay, today was the date and the time that we set this matter for a review. Looks like we were waiting for them to determine clinical eligibility for mental health court. Is that accurate?
Yes, Your Honor. And Mr. Marcos was found ineligible for mental health court.
That's correct, Your Honor. I believe we'd like to leave this on for preliminary examination. The people and myself are going to obviously continue negotiating. We believe there's good chance for potential resolution.
Okay. Get your new date. March 22nd at 9:30. March 22nd. March 28th at 9:30. Yes, that works.
Yes, thank you very much, Your Honor.
No problem. Any additional matters for today's work?
Nothing from the people.
Nothing to advance. Thank you, Your Honor.
Thank you. On the record in the matter, did Ms. Donnelly leave? I don't see her. I see Mr. Palmer. Mr. Palmer, which matter are you here for?
I actually already handled mine off. the
Oh, I do
judge.
see that.
I was waiting on Mr. Notes.
I see that. Okay, we need Mr. Feigelson for Brzezinski.
Mr. Feigelson wasn't, when he spoke with me, he wasn't planning on putting the PCC on the record. He was just leaving it separate prelim.
Okay, Josh Bud, can you unmute, please?
Yes, Your Honor.
What's your full name, sir?
Joshua Johnson Badinsky.
Thank you. Did you speak with your attorney?
No, I didn't get the chance, Your Honor. But I tried to call.
You've never spoken to your attorney?
I tried to call today though, and yesterday.
We need Mr. Feigelson here. Okay, hang tight, we'll find your attorney.
Okay, thank you.
Jared Steele?
Yes, good morning.
Good morning. Okay, we're on the record in the matter of the people of the state of Michigan versus Jared Christian Steele, file number 24-00401 FY, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Okay, Mr. Steele, today was the date and the time that was set for your probable cause conference. Did you hire an attorney?
Yes, ma'am. I tried to call him, but AT&T's been down since last night, so I can't dial out or receive calls. I'm in SOS mode. All AT&T is down.
How did you hire him? Did you pay him?
Yes.
Okay, and he was advised of your court date because you were given that court date in February.
Yes, I was given this court date last week, ma'am.
Okay, what's your attorney's number?
248-569-7776.
Hold on. I do need to contact him because I have, this is Judge Simmons from 54A District Court. I have a person in my courtroom that was scheduled for a preliminary examination. I'm sorry, a probable cause conference today. Yes, in Lansing. His name is Gerard Still. He said he retained Randall Upshaw. Yes. It is. Today's the probable cause, and it's via Zoom. Yeah. The Zoom ID is 876-493-1931. That's correct. The phone number to the court. 517-483-4441. That's actually my judicial office. Thank you. Okay, his office indicates that he's going to be on in just a moment. He's wrapping up another matter. Okay, Mr. Steele?
Okay.
Prelim.
Mr. Smith, did you speak to your attorney?
Yes, ma'am.
Okay, he indicates that your matter is going to continue to exam next week, so you're all set, okay? Mr. Ferguson, you have a client on here who said he's never spoken to you.
That is accurate. We've been playing voice message tab over the past 2 days. Josh, leniency, is that right?
Log on and speak to him.
Just the code.
The jail. His own.
You might have to download the app.
Yeah, that's what I have, but I don't know if they know I'm here.
Hello? Hello?
Hello? Maybe they do. Hello? I'm going downstairs. I don't know if they can hear me.
I can hear you. Start your
Okay.
video.
Okay, let me run downstairs because I'm at work. Okay,
What's your name?
Karen Grace Frank.
I see a attorney known as Hartman.
Good morning, Your Honor. How are you today?
Well, how are you?
Good. I have credit acceptance for Taryn Frank.
Okay. Okay, this is an objection to garnishment. I'm gonna put you, Miss known as Hartman, and Miss Frank in a private meeting room to discuss this matter and see if you can resolve it. If not, then we can proceed with the hearing.
Okay, thanks,
Okay.
Judge.
No problem. Okay, Mr. Feigelson, you met with Mr. Budzinski. Did you all want to continue to exam?
Yes, Your Honor. Thank you.
You, Mr. Bazinski, do you have any questions?
No, Your Honor.
Okay, you're all set. We'll see you next week.
See you next week.
Thank you. Unmute and tell me your name. Well, I wasn't talking about you. I'm muting, obviously.
Sorry, I'm sorry.
You're fine. Ma'am, on the iPhone, can you unmute and tell me your name?
Brooke Church.
I'm gonna mute you until the other party arrives, okay?
Okay, thank you.
This is Mr. Kemp. Okay. On the record in the matter of the people of the state of Michigan versus Kevin Lamar Kemp, file number 23-02774 FY, counsel Chance.
Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Attorney Derek Esposito, public defender on behalf of Mr. Kemp, who is in the courtroom standing to my right.
Okay, Mr. Kemp, today was the date that was set for sentencing. I'm sorry.
He said yes.
Oh, that was you. Okay. Okay.
He said yes, ma'am.
All right. Well, I thought that was you talking, Mr. Fisher. Okay, sounds good. And so I do have a pre-sentence report. It was prepared on the 15th of February. Did you get a copy of that?
Yes, ma'am.
Okay. Do we need to make corrections, updates, or deletion?
Your Honor, there was one addition on the second page regarding employment data. He advised me that he does have a second part-time job working at Burger King, earning around $900 monthly. So he has 2 part-time jobs, Your Honor. There is also a bond violation that we need to address probably before sentencing.
Okay, I have a PA 53 complaint for violation of conditional release. It alleges that you violated the terms of your bond by making or having contact with Jordan Kettler. So you have the right to have a contested hearing on that, and you have the right to be represented by your attorney at that hearing. If you find that you did in fact violate your bond, you could be sentenced for contempt of court. So that means you could be facing 93 days in jail and or $7,500 in fines. Do you understand that? How do we want to address?
Your Honor, I've already spoken with the prosecutor and with Mr. Kemp. He will be admitting to the contact with explanation. The prosecutor agrees not to pursue any charges regarding resisting or obstructing running from the police at the time of this allegation.
That's correct. You want to plead guilty to the violation? Raise your right hand. Your other right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. You can put your hand down. So you understand that you do have a right to have a hearing on the violation, and you do have the right to have some witnesses called or testimony put on and evidence put forth before you can be found in violation of your bond. You want to waive that hearing? Is anybody threatening you to do that? Any promises being made to you if you waive your hearing? Are you entering a plea to the violation because you believe you're guilty? You believe you violated your bond? Okay. As to the PA 53 violation, alleging that you had contact with Jordan Kettler on February 10th, 2024. How do you plead on a factual basis?
I had got a phone call from my mother. She, Jordan Finley is the last, she carried my last two children. And she was having seizures and everything. And I was going to get my children. I was supposed to be up there to get my children. And somebody had called the cops on me because they know I have no contact order with. I was just worried about my children and her well-being. She carried the last two of my children.
You did have contact with her.
Yes, I did. Oh, I did have contact with her.
And police officers came up to the room and saw you there.
Yes, sir.
And then you ran from the police officers.
Yes, sir. Just worried about my children at that time.
Any questions from the prosecution?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea to the violation. I find it to be freely, voluntarily, and intelligently given. So other than the update to the second part-time job, is there any other changes?
There were no other additions, deletions, or corrections, Your Honor.
Took a plea in 55th on the 8th, is that correct?
Yes, Your Honor, he's scheduled for sentencing Monday, is my understanding with Judge Shulman.
Okay, you can make allocation.
Thank you, Your Honor. Now regarding the bond violation, we'd ask him, the court to give him time served. It looks like he was remanded on that on 2/11 and stayed in jail until the day's date. 2/22 as they have on the report. Your Honor, since my representation of him, he's always taken responsibility for his actions. He's pled to this. The report shows that he's taken responsibility. He understands that he did not act appropriately that day and could have handled himself differently. He understands that maybe he needs some counseling to help address his ability to control himself or his inability to control himself in stressful situations. So he's asking the court to follow the original agreement. Do not give him any further jail time. He does have around 38 days credit for this case. He does want the court to order probation with treatment. When he got out, he was trying to get his job back on the schedule of the job so he could start trying to get into counseling. And unfortunately, during that period, he had the bond violation and went back to jail. He's expressed to me his more than willingness to participate in any counseling and treatment. He did follow through with the other requirement of his plea offer agreement and pleading to the other case in 55th. And like I advised the court, to my understanding, he's scheduled for sentencing Monday the 26th, I believe. He would leave the amount of probation and probation conditions up to the court's discretion. He's willing to abide by any the court gives him. And again, he does look forward to trying to get some treatment. Thank you, Your Honor.
No, we probably want to address the fact that the pre-sentence report advises that he has been unsuccessful twice on probation.
He can speak for himself during his allocution, but he believes he can be successful on probation, and he can address the reasons why the court allows his allocution.
Mr. Kemp,
Simmons.
Judge Simmons.
I'm sorry, Judge Simmons. I just want to know chance to prove to everybody that I can't do probation because I'm more mature now. It's about my children. I was going to get out there for my children, and that's why I work 2 jobs. I know in the past, that's when I was young and not thinking wise. But sitting in jail for those 28 days and plus these 10 days showed me how much I want to be around my children and be there and support them. And I do need the help. I do need the classes, and I'm willing to admit that I need the classes and the help for probation. I just want you to give me a chance to do the probation to show you that I'm not going to mess up.
Well, it's more than just classes to probation.
I do everything. I know the drug. I don't smoke. I don't drink. I don't do nothing, but just be there for my children. I'm willing to do whatever your guidelines you have me do. I know in the past I didn't complete it, but I know I'm gonna do it for sure this time, because I'm just on a different path.
Since when were you on a different path? What, the 38 days?
Not just
Put you on a different path?
Not just the 38 days, man. Like, even when I was on the run from everything, I completed probation, I changed it. I just changed. Like, I'm not that same person.
So when you was on the run and not completing probation, you changed and then turned yourself in on those cases?
Yes, man. So I'll get everything over with. I'm not gonna lie to you, but I'm not gonna mess up. I promise I won't. I turn myself in and get all this stuff over with. I just want the chance to show you. I express that to the lawyer and I express that to the lady that did my PSI report. I'm willing to do whatever I have to do. I will complete. That's my goal is to complete.
And then you took a plea to another domestic violence in 55th?
Yes, and when I talked to Mr. Hillman, he was waiting to see what.
Judge Hillman?
Yeah, the judge, I'm sorry, Judge Hillman, he's waiting to see what's going on here, so if I get sentenced probation here, I have to be there at 2 o'clock on Monday, and I will be there. Because
I am not going to deny that I don't have a concern about your willingness to be compliant with the court order and the restrictions that will be put in place if you are placed on probation, because it comes with a lot of hoops that you would need to jump through. And I don't know that you've been able to have the change that you think that you are saying have, but you can show me otherwise. I'll give you an opportunity to show me.
thank you, so much. Judge Hillman, I'm sorry. Thank you, Judge.
I told you twice, 3 times at this point that judges are to be called judge, and you don't even want to do that.
I'm so used to saying this in my mom's from Alabama and stuff like that. I'm sorry, Judge.
I get it. My father's from Alabama, but guess what? I refer to judges as judge.
That's Judge.
You understand that?
Yes, Judge.
You've been in court enough to know better.
Yes, Judge.
Thank you. Okay, so your order for sentencing is going to be 12 months probation. While on probation is a $30 per month oversight fee that you are responsible for. You're not to have contact with the victim. And I can appreciate your explanation as to why you violated the court's contact order. You don't get to decide when you can go around the court order. Were your children at the hospital?
Yeah, they were supposed to be there, but they wasn't. You know,
And so you didn't leave after that?
No, actually, I went to the bathroom, like you said, and I got arrested. That's why. Like you said.
Okay. Yeah, you don't get to violate the court order because you determined that there was reasonable cause for you to do that, because it'll put you back here, okay? So you're gonna have to be a little smarter as it relates to making decisions when it comes to the protection of your children. I don't know what the custody issues are between you and the a victim in this matter, but you need to go to the family court to address that if you need to address custody issues. But as it relates to having communication, I'm going to continue the no contact order, and we don't have the victim here today, do we?
The victim is present. When I last spoke with her, she didn't want to make a statement.
She's present now?
Yes, she's.
And she wants the no contact order to continue?
Yes.
Okay, so the no contact order will continue. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance. You will be required to submit to random preliminary breath testing and urinalysis testing. You have to pay the cost of that, and you're not to be at any bars or nightclubs. Do you have any questions? How many hours a week are you working at these jobs?
I work 35 hours a week at one, and then the other one, I just work 25 hours and I'll pick up extra hours whenever need be.
Okay, you're gonna maintain your employment while you're on probation. You need to provide evidence of that employment to probation. Do you understand that?
Yes, and I will.
I'm gonna order you to participate in some domestic abuse treatment or counseling and anger management.
Yes, yes, and
Probation oversight fees will amount to $360 for doing 12 months of probation. There's also a $75 crime victim rights fee plus a $50 state minimum cost that must be assessed. I'll waive discretionary fines and costs at this time. So your total is $485. You'll be making monthly payments, so you'll be paying about $40 per month on your fines. Do you understand that?
yes, and
If you can't be successful, then you'll just serve 93 days in jail. Okay?
yes, and
Do you have any questions about your probation at this time?
yes, and
This is an advice of rights as to probation. Doesn't really apply to you because you are on probation for domestic violence. But if you were not, you'd have the option or the right to request early discharge from probation once you complete half of the term that I just ordered. But you are on probation for domestic violence, so you don't get to make that request, okay? Do you have any questions about your advice of rights? Any additional matters for the record?
Nothing for the people, Your Honor.
Oh, yeah, thank you.
I have an address for you. Is it still on Viking
yeah, no, Your Honor, it's 2911.
building
Yes, ma'am. Right,
in Lansing?
yes, ma'am.
You have a phone number?
My phone number is 517-204-5866.
Okay. When you will release, you check in with our probation department within 2 days of you being released from custody, okay?
Yeah.
You're all set.
Hang out there.
Good luck, Mr. King.
Yeah, anybody else? Let's see. We know, are we running an exam?
I
Fine.
just, we have to bring them up all. No,
Yeah, you can bring.
And I'm gonna, let her know she can go.
Thank you. On the record in the matter of the people of the state of Michigan versus Anthony Taylor, file number 21-03078. Appearance, please.
Peter Casey Johnson, on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Anthony Taylor, who is present and standing to my right.
Okay, Mr. Taylor, I have a pre-sentence report here. It was dated, prepared February 16th. Ms. Donnelly, you got a copy of that?
I have, Your Honor.
You've gone over that with the client.
I have, and we have no need for any additions, solutions, or corrections.
Okay, you can address the court on sentencing.
Thank you, Your Honor. We certainly appreciate the probation department's recommendation and have no objections to it. Mr. Taylor is working. He has Section 8 housing. He has again, being able to largely stay out of trouble, and, I'm sorry, Your Honor. I was just gonna make sure, since this occurred 3 years ago or 2 years ago, Your Honor, so, again, we just asked that if there's any, discretionary fines or obviously the attorney fees that the court can waive, due to his infancy, that's all we requested.
You might want to make a statement.
Actually, I've been out of trouble since this happened. I've basically put myself back together. Just trying to keep going and stay doing what I'm doing, stay out of trouble and go to work. That's pretty much it.
There's a state minimum cost that must be assessed of $50. Pay that today.
No, I get paid Friday.
You're gonna pay
Or
them-
tomorrow.
You're gonna pay it tomorrow?
Yes, ma'am.
You know how to make payment?
It's been a long time since.
You can either come up and do it at the traffic window right out there, or you can pay it online using this case number, but there is a small fee that is attached if you pay it online. Okay? Do you have any questions?
No.
Thank you. Good luck to you, sir. We're bringing a queen up now.
Yeah.
I'm not seeing Mr. Abbott.
Which one?
Oh, no, we took care of Smith already, correct? Okay, sounds good.
So did they bring up, see, we need to bring it up?
Who?
They're bringing up my guy.
Mr. Feigles, do you have someone?
I do, I have, Nathaniel Coney, we're gonna waive, he's coming up over from, County.
Who?
Nathaniel Coney, C-O-N-E-Y.
Not for Judge Simmons. Nathaniel Coney, oh, 8:30.
Oh, this afternoon?
No, 8:30, there was a probable cause conference.
He's here, we're gonna waive.
Oh, you want to waive the exam?
Yeah.
Oh, okay.
Yeah.
We can have him brought up. I would have had him bring him up already. When he gets here, I'll have him radio up so they can bring him up before we start the exam.
Can I get an opportunity to talk to Aquino before we go on the record? I don't. feel kinda
Yeah,
safe
I
talking
got
to
a
him
bunch of, you don't think what?
I don't feel safe talking to him downstairs in a room alone, so I.
So you want to talk to him where?
Somewhere, like I said, just.
Like the jury room or like?
If, like, basically in the jury box, I don't care, I just didn't want to do it in a private room with him.
You want me to stay in there with you, sir?
You can do that.
I was gonna
too.
say, I can have security go in there with you.
Yeah. I just don't.
I just,
Yeah.
Oh, we're not bringing them up right now anyway, so let's do these.
I'll do
simple.
it.
Okay. Oh, it's right here. Oh, okay. Okay, let's see.
I'm aware.
Still waiting for that attorney.
What's that?
Oh, his attorney didn't log in.
I know, right? Get your little feet
We'll
on.
talk about it.
For, oh, we're doing waiver, yeah. Okay, cool. Well, actually,
Thank you, Judge.
Okay, let's see. Is the attorney on credit acceptance coming up? Okay, I
Yes,
see. Okay, on the record, in the matter of credit acceptance versus Taryn Frank, file number 23-01417 GC, counsel appearance.
Good morning, Your Honor. Attorney Ashley Nonis Hartman on behalf of plaintiff.
Okay, and Taryn Frank is present via Zoom. Ms. Frank, you do not have an attorney representing you, is that correct? Okay. Today was the date set for a objection to garnishment hearing, and counsel, you met privately with Ms. Frank. Did you all come to a resolution?
Yes, so Judge, I did explain why her objection to garnishment would be legally invalid under the court rules. However, we also reached a payment agreement, which would suspend the garnishment. So to state those for the record, Ms. Frank did agree to pay $400 per month beginning March 29th. It will be due the 29th of each month. I did explain the consequence of default, how that works with the garnishment being suspended, that even with the payment plan, we would do the Michigan state taxes. I advised her how to make payments, things along those lines. So moving forward, we will suspend the garnishment, even though the objection was invalid or is invalid, and then we'll move forward with the payment plan. I wasn't sure if you were able to write that on the order you have, or if you would like us to submit a stipulation.
The order I have here, and there was not previously an installment payment order on this, was there?
No, judgment just entered August of 23. There has been no installment payment order, and this is the first time we've had a garnishment.
Okay. And just to clarify the record, she indicated, she filed an objection. I think she said she objected because her written statement from the creditor she believed was wrong. So Ms. Frank, are you satisfied with the statement that you have? Because that was the basis that you relied on.
Yeah, I mean, I didn't feel that I owed that much because the truck wasn't even that much, but they said with the interest that.
Yep, well, nonetheless, I think this was because of a default. Is that how we got to this place? Gotcha. Yep, it was a default. I have an order on the objection to garnishment. I'm going to find the objections invalid. I do need an order as it relates to the installment payment order. If you want to prepare that, attorney known as Hartman, and then that can be filed on my file.
Yes, so I did also speak to Ms. Frank about that. I can draft the stipulation, and I did ask for her permission to sign the installment payment order. So Ms. Frank, if you'd be so kind to state that and that you give me permission on the record, I can have that all submitted today.
Yep, and I do give permission for Ms. Hartman to sign the paperwork on my behalf.
Very good. Okay, and again, you understand that although we are going to be suspending this particular garnishment, they do still have the right to seek a tax garnishment. You understand that?
Yes.
Okay. Do you have any questions for the court at this time?
No, I don't.
Any additional matters for the record, counsel?
I'm on the set. Thank you, Judge.
Thank you. You're all set.
Have a great day, guys. Thanks, Ms. Frank.
You too. Yep, thank you.
Is Ian Smith present? Okay, Mr. Smith, I don't see anyone present for Ian Smith. How did you want to proceed?
Looks like we have good service on this for today's creditor exam. In light of his failure to appear, we'll submit a motion to show cause.
Okay, I'll note that in the file.
Can we do that with 9-day mailing?
Yes,
All right, we will prepare and submit. Thank you, Your Honor.
thank you.
You bet.
Ms. Wanji, do we have Mr. Phillips here?
He's not here.
Why not?
He had a family emergency.
Oh.
Uh,
Did he? That's what he said last week, or last month, I should say. He said that in January. No, that wasn't him, it was the officer who had a family emergency. Well, he tells you what his family emergency was?
his mother is gonna have a open heart surgery this morning.
Is he performing it?
You know, he wants to be around when it's. I understand it's a very stressful situation, but he did call pretrial services yesterday.
Well, thanks for calling pre-shot services, but he had a preliminary examination today. Can he get on Zoom, please?
I gave him the Zoom number, although I didn't give him permission to miss call, to not be here in person, but I did
Of course you
provide
didn't.
him.
He made that decision on his own. He can get on Zoom. We'll talk to him, see how everything's going with his mom. Okay. Okay, I see Brooke Church and then Mr. Lum.
Hello, good morning. I'm Brooke Church.
Good morning, Your Honor. Brian Lum on behalf of the defendants.
Okay, this is Church versus Hicks and file number 23-01873 GC. Let's see, no pre-trial statement was filed. And I already have your appearance for the record, Mr. Lum. And then Ms. Church, you are representing yourself, correct?
That is correct, Your Honor.
Okay, and so this is on the docket, I'm assuming for some motion. I have a motion here. It says, I am pleased requesting to add another party who is also responsible. Bruce has multiple parties who have been involved. I would like to add Coast to Coast Properties because they also are part of this case. On February 6th, I dismissed this case for lack of progress. Were you aware of that?
Was I?
Yeah.
No, I was not. The last thing I had was I had to submit interrogations, and that's what I did last.
Interrogatories.
Yeah, excuse me, I'm sorry.
No problem. And I do see that there are some interrogatories here in the file from January 19th. Let's see, pretrial statement was supposed to be filed in this matter. I don't see where we ever received your pretrial statement, and that's why the case was dismissed.
For me?
Yeah, you're the plaintiff, so you're responsible to make sure it gets done. So when you came to court back in November, I advised you and Mr. Lum that you have to complete a joint pretrial statement. I've not received one, and that's what we use to kick out our scheduling order. So the clerk's office notified me in February that there was never a joint pretrial statement filed since November. Mr. Lum, did you all complete a joint pretrial statement?
We did, Your Honor. I emailed it to Ms. Church, but didn't receive a signature back.
Yeah, because you said I could say that you could sign it over the phone, and I said that.
Okay, well, the court didn't get it, and that's the problem. The court never received it. And Mr. Lum, how are you serving her interrogatories if I haven't entered an order granting you to do that?
I filled out all of them and just received them all as well.
I recognize that, but he can't give you interrogatories or discovery without the court permission. So I need a joint pre-trial statement. I'm going to construe this as instead as a motion to set aside the dismissal and reinstate the case. I will reinstate the case. I want you all to go in a private meeting room today, get the joint pre-trial statement reviewed and make sure it's up to date the way you need it. Mr. Lum is going to be responsible for getting it to the court.
Okay, thank you, Your Honor.
Only because he knows how to get it there. And then if you want to give him permission to sign on your behalf, you can do that today, okay?
I do also have a question. Those that he wanted me to fill out, they did state times and dates that the heat wasn't working in my house. And I'm actually currently,
you can ask him those questions. You can ask him those questions privately. But right now we need to get the joint pretrial statement, because if we don't get the joint pretrial statement, you don't have to worry about answering any of those questions. The case will be dismissed for lack of prosecution, okay? So let me put you in the meeting room and let's take that step first, and then we can deal with how much discovery the court's going to even allow on a civil matter, okay?
Absolutely. Okay. Thank you for clearing that up.
Dang. It's probably because he's got the scrubs on and he's in surgery. Let's see here. Where's that file so that I can put bench warrant? I'll give him 48 hours to turn himself in before I issue it.
Thank you.
I think I have it. It's right here. Have a good one. That was Phillips. Okay, let's see. Is Richie Colby present? Okay, let's see. On the record in the matter of Astera Credit Union versus Richie Ray Colby, AKA Richard Colby, file number 23-01892 LTE, counsel appearance.
Good morning, Your Honor. Randall Grundyke for Astera Credit Union.
Okay, today was the date and the time that was set for a motion for entry of order of eviction. Let's see here. The tenants failed to appear. This is after a default back on September 27, 2023. The property still occupied?
It is, Your Honor. The possession judgment was entered following the expiration of foreclosure and the redemption period. Mr. Colby remains on the property. He's been given ample time to find another place to live, has not done so. He's refused to voluntarily vacate. I can tell the court there's been no agreement between the credit union and Mr. Colby or any payments made or received. And we'd ask that the court enter an order of eviction at this time.
Okay, and it appears he failed to appear back in September 27th as well. So this is not his first failure to appear. Your motion is granted. I've entered the order time for today.
Thank you, Your Honor. And I believe we filed an order of eviction with the court. Does the court have that, or would the court like us to submit one now?
Application in order of eviction, let's see, is what I just signed. For the 20, you submitted that on January 31st?
I believe my assistant submitted that at the time we filed the motion, but if it's not in the court file, we can submit
Correct.
another.
Your application in order for eviction is here. It's date stamp received by the court on February 5th, so that's what I signed.
Thank you, Your Honor.
Thank you. Have a good one.
Thank you. You too.
This is Mr. Coney.
Yes, it is, Your Honor.
On the record of the matter, the people of the state of Michigan versus Nathaniel Wade Coney, file number 24-00195, FY, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Nathaniel Coney, who's standing to my right this morning.
Okay, how are you, Mr. Coney?
Good, how are you, Your Honor?
I'm doing well, thank you. Okay, today was the date and time set for probable cause conference. Matter was scheduled to proceed to exam on February 29th at 8:30, and my understanding is that there's an unconditional waiver.
That's correct, Your Honor.
Okay, was there an offer?
I believe all negotiations were going to be taking place at the circuit level.
That's an accurate statement, Your Honor.
Okay, so Mr. Coney, understand that you have the right to have a preliminary examination in the district court.
I do, Your Honor.
You understand the purpose of the exam?
Yes, I do, Your Honor.
You have the right to require the prosecutor put forth evidence to establish they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
I do, Your Honor.
You wish to unconditionally waive your right to examination.
That's correct, Your Honor.
That's not something that you're doing because someone's threatening you, is it?
No, Your Honor.
Any promises being made to you
No, Your Honor.
for a waiver? You understand that once you waive it, the right to the exam is gone. You can't get to circuit court, not like you're offering to change your mind. You understand that?
I understand, Your Honor.
Find over date's gonna be March 6th. That's the date circuit court's gonna get the file from the district court. You do not have to appear on March 6th to the circuit court. You understand that?
I do, Your Honor.
Next court date's gonna be a pre-trial in circuit court. Mr. Feigelson will be made aware of that date. You'll be in contact with him. Let's see here. And bond set at 7,500, 10% will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing on behalf of Mr. Cooney, Your Honor.
You're all set. Thank you.
Thank you, Your Honor. Have a nice day.
Thank you, Mr. I'll be in touch.
Mr. Steele?
Yes, ma'am.
Okay, I have Mr. Upshaw's law office on the phone. They said you did not retain their office.
Excuse me, can you repeat that, Judge?
The attorney's office that you claim that you retained, it was Randall Upshaw, correct?
Yes.
They said you did not retain them.
Okay, my brother was supposed to be meeting up with him. I don't know if he did or didn't, but that's what was sent to me when I was incarcerated.
Okay, well, that's not the case. Thank you, ma'am. That's not the case. So do you want to meet and see if you can get a public defender in the interim? And then you, if your brother does decide to retain counsel, then they can substitute counsel, but you can't just sit here and wait for your brother to decide if he's going to retain counsel for you. You have a matter that needs to proceed. You understand that?
Yes, ma'am.
Okay, so did you want to do an intake and see if you can get a public defender while you figure out what's going on with your brother?
Yes.
Okay, I'll get a public defender to log in and meet with you in just a moment, okay?
Okay.
Who do you have with you?
I have.
Oh, yeah, I'm talking to you. You have Mr.
Aquino.
Aquino, okay.
And we're gonna waive, Your Honor.
Okay, on the record in the matter, the people of the state of Michigan versus Mark Anthony Aquino, file number 23-03744, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Mark Aquino, who is present standing to my right.
How are you, Mr. Aquino?
Doing all right.
No, and I can put on. Yeah, that's fine. Yeah, it's fine. Yeah.
PA 53. Okay, I have a PA 53, a complaint for violation of conditional release indicating that you have violated or allegedly violated your bond conditions by having multiple third-party contacts with Ryan Rakin from jail, leaving threatening statements. We won't be doing a waiver today because we're gonna handle the PA 53. You have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you're found to be in violation of your bond, you are going to be serving 93 days in jail on the violation. And you also are subject up to $7,500 in fines. Did you all get a copy of this police report?
Yes, yes, Your Honor.
You were aware of these violations?
Yes. I'm covering for Mr. Pfeiffer today. Just for the court's sake, I do believe that the people, as part of an agreement with defendant, the people would not be pursuing the witness intimidation charges that were made prior to this date.
Prior to the 8th of February?
Yes, excuse me, yeah.
That's fine. That has nothing to do with the bond that the court set. So the court's still dealing with the bond violation.
Understood.
So Mr. Pfeiffer can be here for that. If that's what he wants to do. I'll set up for hearing. I'll enter a plea of not guilty on that. March 15th at 9. March 15th at 9. In the, I think we've already suspended his phone privileges, did we not?
Yes.
Maybe we find some more privileges to suspend because I don't know how there's allegations of third-party contact. Okay, well, it looks like I'll go through this account and find all the people that were stupid enough to allegedly let you use their accounts to make contacts. I'll restrict their contacts until the time of the hearing. Is there maybe another way I can communicate to you that there's no contact between you and the victims in this matter that includes third-party contact? Is there another way that I could communicate that to you?
I get it now. If you want.
You get it now? You didn't get it before? Okay. Okay, we'll get the witness subpoenaed here and the detective who submitted this report subpoenaed for the 15th. Any additional matters for the rest of today?
Nothing for the people.
Nothing for defense.
You're all set. Thanks for writing the note on this one as well.
Remy.
Yes. Darren Clark.
I'm gonna go release my officers from. Okay, just be a second.
Okay, back on the record in the matter of Brook Church versus Bruce Hicks. Did the parties complete their joint pretrial statement?
We did, Your Honor.
Okay, and Ms. Church, you give Mr. Lum permission to sign your name to it?
I do, yes, Your Honor.
Okay, so he'll get that filed with the court. You'll now receive a scheduling order for your next dates based on that. And it looks like you've already gotten some discovery and that you've already completed those or have almost completed them. It looks like your discovery responses. Let me see here. Are you still at the address on Farrell Street?
Yes, I am, Your Honor.
Okay, that's where your next notice to appear will go to. Any additional matters for the record today, counsel?
We would ask for some additional time for discovery for the production of documents and release of medical records request.
Okay, the joint pretrial statement should have addressed all of those the timelines that you needed.
Okay. Should I file this through my file, Your Honor?
Yes, please.
Thank you.
Okay, once you I receive that, I'll review and I will sign that, and then you'll get your next court dates. Make sure, Mr. Lum, that if you do need time allotted for requests for some medical records, because I'm assuming she's claiming some injury, that's already into the order that you're submitting to the court, or your statement that you're submitting to the court. Okay.
Okay, thank you, Your Honor.
Any questions,
I do have
Ms.
a
Church?
question, Your Honor. Yes, please. I thought that I have submitted to you and him all of the medical records that I have had.
I
I
don't
did it
know what
myself.
you submitted. There's a very thick file here, but the court does not receive evidence until it's properly submitted at a trial or hearing for that. So I don't know what you submitted. So if you have a copy of those medical records, I don't know if that's something that will satisfy his request. He may want the medical records directly from the medical provider, which may need you may need to give a release for that, okay?
Okay, that's fine. Yeah, that's fine.
Okay. Do you have any other questions?
No, that's it. Thank you for clearing that up. I appreciate it.
No problem. You're all set for today. Thank you.
Thank you. Have a good day.
Same to you. What's your name, sir?
Lawrence.
Donnelly's case. Hmm? Yes, we agree. That one. Okay, on the record, in the matter of the people of the state of Michigan versus Darren Clark, I have file number 24-00099 SM. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Darren Clark, who is present and standing to my right.
Okay, how are you, Mr. Clark? I'm doing well, thank you. I have here a misdemeanor complaint that alleges that on or about September 17, 2023 through September 28, 2023 at the area of 3106 East Saginaw Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of retail fraud, 2nd degree. The allegations are that you did, while Rite Aid was open to the public, sell property of the store that was offered for a sale price of $200 or did while or more but less than $1,000 contrary to Michigan compiled law 750.356D. Count 1 is a misdemeanor with a maximum penalty of 1 year and or $2,000 in fines or 3 times the value difference in the property stolen, obtained, or attempted to be obtained, whichever is greater. You understand the charge and the maximum penalty attached to that charge. So you do have the right to have counsel represent you during the pendency of this charge, and you do have court-appointed counsel on your other matter. But you want to request the public defender's office to represent you on this one as well. Okay, so the court will enter a plea of not guilty on your behalf, but I am going to advise you that you have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to a jury trial, and you have the right to a jury trial. You enjoy the presumption of innocence, so that means you're innocent until proven guilty. You have the right to require the prosecutor prove your guilt at a jury trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any witness the prosecution intends to call against you. You have the right to call your own witnesses and present evidence that you believe show a defense to the charge being brought against you. And then you have the right to remain silent at your trial and not have silence be used against you. Do you have any questions about those rights? The address that you gave on your other file for the Northeast Capitol in Battle Creek, is that still a valid address? Okay. Okay, let's see what's going on here. I'm trying to see why these files look like they are connected.
I believe this is the similar date of offense in what we have, right? Rite Aid, is that where, it's the same Rite Aid, right?
That's exactly what my question is. It's the same exact Rite Aid and the affidavit of probable cause.
But
On the other ones, let's see here.
they happened in September, so
Just talking about the theft though, that's why I'm trying.
there was, when Mr. Clark was arrested on the charges he's here today for, there was suspected that he had stolen like air fryers or something.
Got it, I see that here. Okay, so on that, on the 2nd of October, which would have been after this, the people from Rite Aid must have just called because they saw him there. That's what it is. Got it, okay. This matter is gonna be set for pretrial. Your pretrial is gonna be March 26th at 8:30 in the morning. We'll make sure this file has the updated address. They put it in as unknown. I don't know why, if his address is on the other file. by the way. Address is 1417 Northeast Capitol. Apartment 36. No phone number though. Okay. A bond is set in the amount of $500 personal. Let's see here. Is he on PR bond on both of these?
Yes, Your Honor. That's what we
That's
want.
what you would prefer, because he wouldn't be accruing any time, obviously.
No, that's fine.
Okay, and then, while out on bond, you're not to engage in any assaultive or threatening behavior, you're not to use any drugs or alcohol without a prescription, you're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without approval of the court. You're not to be at the address of 3106. Not to be at the address of 3106 South Saginaw. Although I think that writing might be close. I could be wrong.
I'm sure.
If
This
that's
is the
the one,
Frankfurt one, right? I think it is.
oh, that's South Saginaw? That could be, I'm not sure. Saginaw.
Which I used to Saginaw, but.
Oh,
The affidavit of probable cause says South Saginaw. That's why I was like, where's South Saginaw? Okay,
No, he won't,
either way, he won't be at that address.
Yeah.
He knows allegedly what address it is. So South Saginaw, East Saginaw is what you have.
Yes.
Let me see what it says on this one. It should be East Saginaw. I think they put it wrong on the affidavit. I don't know that there's a such thing as South Saginaw.
East or west? Yeah.
East Saginaw. Okay, there we go. That's noted here. Do you have any questions about your bond conditions? I can't hear you.
No, ma'am.
Okay, and how are we proceeding on the possession of meth charge?
Your Honor, there were these additional charges. There's a global offer that we're hoping to reach here in district court. There is one more, I believe, felony file with a retail fraud that needs to be filed out in 55th. So at this time, Your Honor, Mr. Clark is being held in Calhoun on a sentence. He won't be released until May. So hopefully that we will have this global resolution done in time for him to be released. So we're just asking for an adjournment. I don't know, I can't remember, was this set for a preliminary exam? So we would adjourn it. We've already found good cause and we'd have this set for plea.
This is the concern. These in Calhoun County, it costs us money to keep going to get them. And then they gotta go get him and bring him to 55th. What is the global offer?
So we are still discussing, but likely it will be some sort of misdemeanor, likely a use of controlled substance.
You said it's a felony in 55th?
Yes.
It'll be a possession, another possession.
Oh, yeah.
And retail fraud second, that'll be filed out there. So, and he already has an offer before these two files were in review for a misdemeanor use. So I'm hoping like maybe use and a retail fraud second.
Something along those lines. Yeah, I just gotta hammer out the details.
When's his court date in 55th?
That's the thing, Your Honor. They have to do the swear to still.
Yes.
Yes, I understand. I don't want him to the extent expense or time. I want Mr. Clark to get.
Yeah, we can't bring them back just so we can find out that they're not ready on the other one, and then we gotta reset it. And then we have a plea and then a sentencing date. When I bring them back, I expect to have the plea and sentence the same date.
So it just really depends on how fast you think you can get the swear to, but we want to set the plea late March, early April, and hope that it all gets done then.
Oh, yeah.
Late
You
March,
said it.
how about that? Late March.
I'm gonna set it for March. And Ms. Petrowski will know whether or not that we need to reset that before that date. So I'm gonna hold the prosecutor responsible if we send the Lansing Police Department to retrieve him at their expense when you know that the matter is not ready to take a plea here. So we'll reset it.
Thank you.
March 28th. March 28th at 9:30. You have any questions today? Let's see, we can reset that retail fraud out further than that. Actually, we're gonna set the retail fraud for March 28th.
Okay. Yeah, I'll have myself
The
assigned.
same
to Your Honor.
date as the at 9:30. Any additional matters for the record?
No, Your Honor.
No, Your Honor, thank you.
Thank you, you're all set. Mr. Abbott, how are you?
Good morning, Your Honor. I am well. I apologize for my tardiness.
Tardy for what?
PCC regarding Willie J. Wan Smith.
Oh, I said he spoke to you,
Yeah, I spoke to him yesterday.
and I was told you wanted to continue.
Yes.
I
However,
didn't expect you to come.
all right. Since I spoke to him, I spoke to the prosecutor, and they've arraigned the wrong guy.
What do you mean?
I mean, they arraigned Willie J. Wan Smith, who was born in 1985, and who they want to prosecute on this case is Willie J. Wan Smith, who was born in 2003. Because they want to prosecute his son that they got the game.
That happens.
So,
I remember when my dad passed away, my brother got arrested for driving while license suspended. He's a junior. You gotta tell him. It's not me. It's not my date of birth. So that's what's going on. We have the wrong, are they both in custody? Or was
I spoke
this
with-
one that you spoke with, was he already in custody or is he in custody on this?
he's already in custody, and he
Okay.
has been for several months, which led me to question how in the world he could have gotten a new case. He's been in jail since
Stranger
August.
things have happened.
Certainly, Your Honor. But looking at the police report, it's Willie J. Wan Smith Jr., who's alleged to have committed the crime we're here for today. So they arraigned the wrong guy.
Let me see the file. Did he take it?
I might have misunderstood you. I thought that we both had initially been like, oh, junior, senior. I didn't realize that they had actually gone through a brain the wrong individual. So
You
my
did.
apologies for the confusion there.
Yeah, well, it's kind of unusual.
Yeah.
Usually they try to figure out who they're who.
Who's the one in custody?
One in custody here in Ingham County, Your Honor, is Willie J. Wan Smith, was born in 1985. The person that they are trying to prosecute was a person that was born in 2003. He's in custody. We talked to the grandma. She knows what it is.
Grandma's always known so.
How long is the one you spoke to, I should say, how long has he been in custody?
Since August 28th.
Definitely not him.
If you look at the court record on the computer, the website that for the 54A, they've got the right birthday there. They distinguished between the two.
Okay, got it. Okay, so this is gonna need the Summons, let me double check on you. Well, summons would have been sent already, I believe, let's see. Complaint. Summons was sent. He was, funny thing, summons was sent, he was supposed to be here on the 15th of February for arraignment. According to the court record, the summons was sent to the address of the person with the correct date of birth. Okay, I'll get it taken care of. On the record in the matter of the people of the state of Michigan versus Douglas Morris Jr., file number 22-01038 SM, counsel appearance.
Excuse me, Assistant Prosecutor Paige Petrowski on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Douglas Morris, who is standing to my right.
Okay, Mr. Morris, I do have a pre-sentence report dated prepared February 15, 2024. Ms. Donnelly, you got a copy of that?
I did.
Do we need to make corrections, updates, or deletions?
No need for that, Your Honor.
Mr. Steele just walked back in. Oh, did Mr. Abbott leave?
Yes.
We need to grab him. Could someone run in the hallway and ask him to log on to Zoom? I got a project for him.
Yeah.
There's a defendant who needs an intake. Are you able to log in and do an intake with him?
Yes, Your Honor.
Thank you. Mr. Steele?
Yes, ma'am.
Okay, you logged off, but you're back. Are you ready to do the intake?
Yes.
Okay, I'm gonna put you in a private meeting room and then Mr. Abbott from the Public Defender's Office is gonna log in and meet with you privately, okay?
Okay.
Okay, let's see. Okay, no corrections, updates, or deletions?
No, Your Honor.
You can make allocution.
Thank you, Your Honor. I do want to address the pre-sentencing report. I understand that, it's my understanding that Ms. Duhosky did a substance abuse assessment and found that interpreted a level of defensiveness in his answers, possible defensiveness, as being a high indicator of a substance abuse disorder, and recommended intensive outpatient programming. I believe that intensive outpatient programming is a good recommendation. I just want to talk about a little bit about why he needs intensive outpatient programming. I think this is an unusual situation in which we have Mr. Lawrence this is obviously his third OWI offense, even though it's being entered as an OWI second. It's his third offense and in his lifetime. It has been 7 years from the date of his second offense, which was, again, more than 7 years from the date of his first offense. Mr. Lawrence has his criminal history going back to his very earlier days so I say that because I believe that the rehabilitation or whatever programming he needs is a little bit more varied than just merely about substances. I believe there might also be indications that he might need some other counseling, or certainly early on in his life, his OWIs, I think, stemmed definitely from substance abuse. And obviously he was drinking and driving in this offense too, but his explanation for why he was in this incident, why he, because I asked him, it's like, Well, after the first offense, most people would be so scared to drink and drive that they would never do it again, but he did it 2 more times. And it seemed like on the third time, there might have been some other decision making that he might have, basically it came down to it is he was asked to do a short errand. He wasn't expecting that errand, but he had been drinking. He should have said no, but he didn't. And I believe that there might be some, again, the tools that are offered by intensive outpatient programming, I think are very much appropriate here. So, Your Honor, with that, I don't, like I said, and of course, it's been 2 years since, I believe this date of offense on this one took place in 2022. So again, we're about 2 years out from this. Mr. Morenz otherwise has been a law-abiding citizen. He works full-time. He got a factory job last November that he's been able to keep. He has a significant other. He has a 6-year-old that also he shares with his significant other. He lives in Grand Rapids. We have otherwise we have no objections or recommendation. We believe that he is a good candidate for probation. He needs services, and he needs to be monitored. The only other thing, Your Honor, would be under the recommendation. I was a little confused by the recommendation. It says 180 days in jail. They recommending 180 days in the Ingham County Jail, credit for 1 day, and then suspending 170 days upon completion of probation. So I just wanted to know what was the recommendation, that he do 9 days jail. I
have zero idea.
But if that's the case,
They may have made an error.
Yeah, because if that's the case, Your Honor, we would just be requesting, if at all possible, that he can do it on his weekend, so he can still work.
Yeah, they might have typed 0 instead of 9 because it's right next to each other. It's the only thing I consider as to why it would say 170 days if only 1 day was actually served. You might want to make a statement. I'm just a little bit overwhelmed and concerned how it is that we are before the court for the 3rd time for drunk driving. In this particular case, and I recognize your attorney has put on the record what your explanation was. I don't believe there's ever a reasonable explanation as to why you need to operate a motor vehicle while you're intoxicated. But my understanding of the explanation is that you were enjoying a basketball game, drinking, correct?
Yes, ma'am.
And then there was going to be a celebration of life, a funeral service that was going on. And someone needed to borrow your PA system.
Yes.
And you thought it was reasonable for you to drive or get behind the wheel of a vehicle under those circumstances, and your blood alcohol level was over 0.32. That's so far above a super drunk that anyone who could even function with that kind of blood alcohol content, it demonstrates to us that you have a serious issue because your body is still functioning with something, because the average person who doesn't drink like that with a 0.32 would probably be sick or could go into some kind of alcohol poisoning or shock. That didn't happen for you. Not only did it not happen for you, you got behind a motor vehicle wheel and drove for an explanation that you needed to deliver a PA system for a funeral.
Well,
Not a funeral, celebration of life.
for a celebration of life.
Yeah.
And you thought that was a reasonable explanation as to why you did what you did?
Not.
Oh. When was the last time you had something to drink?
Was when I was bonded out.
Okay, so if I were to have you do a PBT today, it won't show anything? Excuse me?
No, ma'am.
Okay. The other concern that I have is you've been terminated from probation more than once. Why would you be a good candidate this time?
In previous times, first one was, I was 21, young, college. There. Second one, I was early 30s, single guy. And kind of thought I could get away with it, I guess. But now I have a significant other that we've been together for 10 years. And, I have a 6-year-old son that lives with me. So priorities are much different.
Well, didn't you have a significant other and a son when you made the decision to get behind the wheel of the car with a 0.32 or above blood alcohol content?
Yes, ma'am.
Those things are not the reasons why you changed. I want to hear what has happened since February 26, 2022, that will cause me to believe that you are now in a position to take hold and grasp the issue, which is substance abuse, and to be successful on a term of probation.
Because I need to take care of my family.
So you needed to do that before.
Yes, but I was obviously intoxicated, making bad decisions on that day.
Okay, and then in the area where you live, it's limited opportunities for you to test. Is that my understanding?
I guess not. The probation officer said that they closed January 27th.
I think the recommendation from the probation department is appropriate. I think that you obviously need some intense patient treatment. The probation department believe that you didn't view your alcohol use as problematic. Is that true?
Yes, ma'am.
It's true? You don't think your alcohol use is problematic?
No, I mean, I work full-time, I take care of my family. I just I drink on weekends when I don't have anything to do. I'm responsible, I pay all my bills, so I do everything that I need to do.
Driving drunk is not responsible.
That day it was not.
It's not the first time you did it. It's the third time in your life.
Yes, ma'am.
Which is far too many.
Yes, ma'am.
And you think your alcohol use is not a problem?
Well, it's gotten me in trouble, yes.
Okay, well, it sounds like there's some denial going on there, which is typically the first step. You got to get to the point where you recognize for yourself that you have a problem. And I can guarantee you, unless you recognize that, whatever we're about to order you to do is not going to help. Because you have to make a determination that, hey, I have a problem and it needs to be addressed because I drink and I'm drinking a lot and then I'm getting behind a vehicle. And it's not happened once, it's not happened twice, it's happened 3 times. And I don't care if there was a 7-year gap in between that. Are we supposed to wait until the next 7 years where you get behind the wheel and this time you kill somebody or you kill yourself? Are we supposed to do that before you realize that there's a problem? I'm going to put you on a term of 12 months probation. Okay, I'm going to order 180 days in county jail, credit 1 day, suspend 179 upon successful completion of that 12 months of probation. You're not to use, purchase, or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription. Do you understand that?
Yes, ma'am.
You are not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. In order that you attend a 12-step meeting 3 times a week and provide verification to probation that you have been completing that. You need to complete a victim impact panel within 90 days and provide verification. And I'm going to order you to participate in intense outpatient treatment. You need to maintain employment and provide evidence of that to your probation officer. You will be required to submit to random preliminary breath testing and urinalysis testing to the extent that that's available to you in the area that you live in. Because at this time, there is none available, I am going to order a sober link. Do you have any questions about your probation conditions at this time?
No, ma'am.
It's a $30 per month oversight fee that you're responsible for, so that's $360 for 12 months probation. We discussed with him already what his license restrictions would be.
Yes, Your Honor.
$75 crime victim rights fee that will be assessed, plus a $50 state minimum cost. And then you owe the police department $563.89 for responding to this incident. So that's a total of $1,048.89. You'll meet with probation because they'll go over this order with you, and they'll advise you of how much you'll be paying monthly, but you're paying about $88 a month in fines and costs. I'm gonna waive discretionary fines and costs part. so that you don't have to pay in addition to that at this time. Do you have any questions about your fines and costs? Lastly, there's an advice of rights as to probation. It advises you when and how you can make a request for early discharge from probation. You have to complete half of the original term ordered by the court without any violations within the 90 days preceding that request. Either your probation officer can make the request or you can make the request on your own. It tells you on there what the form is that you would use to make that request. If it's set for a hearing to address your request, you have the right to hire an attorney to represent you for that hearing. You do not have the right to have a public defender represent you for a hearing for early discharge. You should review that file and then ask me any questions if you feel like you have any.
No question.
No questions. Okay, you can give me that back. You'll check in with probation once you leave here today. Do you have any additional matters for the record, counsel?
Nothing for the people, Your Honor. Nothing for defense. Thank you.
Thank you. You're all set. Mr. Abbott, are you and Mr. Steele all set for today?
Maybe, Your Honor. He's currently charged with a felony. I understand today was a PCC date. I'd ask for an extension, a waiver of the 21-day rule, and a new date for a preliminary exam.
Okay, let's see, Mr. Day, because of your need for counsel, I am gonna find good cause to go beyond the 21 days, and I'm gonna give you new court dates. I'm sorry, am I looking at the right file?
It's Gerard Steele, Your Honor.
This is Mr. Steele, not Mr. Day. Did I give him the file back? No, I have it. Mr. Steele, I'm gonna find good cause to go beyond the 21 days. Give you a new probable cause conference. We can do probable cause conference on February 29th at 9 a.m. actually. And I'll get you a new exam date. We can do it April 18th at 9. April 18th at 9 a.m. Do you have any questions for the court today, Mr. Steele? You're muted, sir.
Sorry about that, Judge Simmons. No, ma'am, I don't have questions.
Okay, any additional matters, Mr. Abbott?
Yes, could you please tell me the case number and the nature of the charge?
Yes. At 24-00401, count 1, controlled substance delivery manufacture. Count 2, weapons, firearm possession by prohibited person, and then counts 3 and 4 are a weapons, felony, firearm.
Thank you. Nothing
Thank
further.
you. Thank you. You're all set, Mr. Steele.
Thank you. Have a nice day, Judge.
Yes. You're all set.
Thank you. Have a nice day.
Same to you. Okay, why did I still have Mr. Day's file? Oh, I need to contact the jail, that's why. And I need to contact the jail on that one, and I need to get this one fixed. And then we just have this one at 1:30.